my name's Gillian and I'm a solicitor in the private client team at Gillespie Macandrew. And so I'm assuming that most of you are here because you're responsible for children who need and might continue to need help when it comes to making decisions about maybe their health and their welfare, or maybe managing their finances. So my task, it's going to be over the next sort of half hour or so, is just to outline the best way for you to formalise your authority to act on your child's behalf when they become an adult. So what I'll do is I'll go through the talk, and then at the end, as I say, we'll stop recording and then we can have a little bit of time for any questions that you might have. So what are we going to cover tonight? So over the years, I know my team has done a lot of work aimed at helping families of children with additional needs. And it's the same issues that keep cropping up, especially when it comes to powers of attorney and guardianships. So that's going to be my main focus tonight. But I'm also going to start by having a look at the legislation which governs powers of attorney and guardianships. And then we will look at the actual powers of attorney and guardianships and how they work. I'm also going to touch on what's known as intervention orders, but I'm not going to go into them in as much detail because they're not very common. So don't worry, I promise there won't be too much law involved, but I think it is important that you do know what the basics of the law is. Just because if you are going to be acting as maybe a guardian or an attorney at some point in the future, it's good to have that knowledge. So if we take a look at the legislation first of all, so powers of attorney, intervention orders and guardianships, they're all governed by the Adults with Incapacity Scotland Act. So what did this law do? It introduced a new system in Scotland in the year 2000 for safeguarding the welfare and managing the finances and property of adults who lack capacity to make decisions themselves. And it also created a new body called the Office of the Public Guardian. You might have heard of them, but they play a very important role in supervising the use of powers of attorney and of guardianships. So now when we're talking about adults with incapacity. So what does that mean? Well, an adult basically is just anybody who is age 16 or over. So 16 is the crucial age here, and it's when your child turns 16 that your parental authority to make decisions starts to fall away. So that's why when you're looking at transitional planning, you really want to be looking at powers of attorney and guardianships as part of that. So we're talking about adults with incapacity, but what does incapacity mean? So the basic definition of incapable is given in the legislation. You'll see it there on the screen, but you'll know better than I do that incapacity is not an all or nothing. It's not black or white. There's lots of different shades of grey when it comes to incapacity. So I just want to stress that this is just a legal definition. And so it says that incapable means incapable of acting or making, communicating, understanding, or retaining the memory of decisions by reason of mental disorder or of inability to communicate because of physical disability. So that's what incapable means. Now, I don't want to get horribly legal and technical about how the legislation works, but I think it's really important that you know the principles which are set down at the start of the legislation. Now, these principles, they're not just for show. If you end up being an attorney or a guardian for your child, you'll have to follow these principles whenever you make a decision or whenever you act on their behalf. So there are 5 principles in total. So if you just bear with me, I'm just going to go over what those 5 principles are. So the first principle is the benefit principle. And it means that any intervention that you make, it must be necessary and it must benefit the individual. So any step that you take on behalf of your child must be justifiable, and it must be for their benefit and with their best interests at heart. And I'd say this is probably, you know, the most important principle, and it kind of underpins the whole legislation, that everything that you do must be for the benefit of your child. The next principle is called minimum intervention. And so this means that the thing that you do, it must be the minimum intervention necessary to achieve the purpose. So it's got to be the least restrictive option to the individual's own freedoms. So in other words, don't use a sledgehammer to crack a nut. Now, the third principle we've got is you have to look at the individual's wishes. So you need to take into account the present and past wishes and feelings of the person who you are making decisions on behalf. And you should try every possible means of communication to find out what their wishes and feelings are. You know, you should be thinking, what can they tell me about their likes or their dislikes, their hopes and their fears, and maybe what their goals are. If they can't communicate them now, then you should look at what they've maybe been able to say to you in the past. And we should be trying hard to find out what their current views are. It might be that they just need a bit more time or support to make their wishes known. And we should do our best to communicate that. One of my colleagues actually prepared a power of attorney for a young person who had had an aneurysm and had lost the ability to speak and to write. So a lot of people might think, well, you know, if somebody can't speak or they can't write, then they won't be able to put a power of attorney in place. But he sat down with her for quite a long time and asked her a series of questions, and she was able to answer the questions by using hand signals and also by nodding. And from that, he was eventually able to determine that she did have capacity, and so she was able to put a power of attorney in place. So we really have to try to overcome any communication barriers, such as, and you know, we can use advocacy workers, maybe speech and language therapists, or specialized equipment and things like that. So if you're looking to have a solicitor to help you put a power of attorney in place, you know, don't feel free to tell them how they can communicate with your child best and any steps that they can take to make it easier to put a power of attorney in place. So, you know, a good solicitor should take the time and effort to really find that out. The fourth principle is in relation to consulting with relevant others. And that just means that if you're making a decision as someone's attorney or as a guardian, you should take into account the views of the nearest relative and the primary carer, and anyone else who's got an interest in that person's life. Now, a lot of the time, if it's you and you're acting for your child, you probably will be the primary carer and the nearest relative. But it's just worth keeping that in mind. And this, the last principle, so principle number 5, is in relation to promoting skills. And that means if you're acting as an attorney or a guardian, then you should encourage the individual to exercise whatever skills they have when it comes to maybe managing their finances or making decisions about their welfare. And also you should try and help them to develop new skills if possible. So it's not a case of you just making decisions for that person. You should be trying to maximize their input, and you should try and help them to participate in the decision making as much as possible. So those are the 5 principles that you should always keep in mind if you are acting as an attorney or as a guardian. So we'll go on now to have a bit of a more in-depth look at powers of attorney. So what is a power of attorney? A power of attorney is basically a document that allows you to appoint the people that you trust to make decisions if you're not able to do so yourself. So it basically allows your attorneys to step into your shoes and do the things that you would normally do for yourself. So it might be that your child, when they turn 16, they will have the ability to understand what a power of attorney is and what it does, and they might be able to sign a power of attorney in favour of you. But as I say, they must have capacity to understand what they are signing, and the instructions must come from them. Okay, so it can't, you can't instruct a solicitor to prepare a power of attorney. It would have to be your child who does that, and it would have to be when they turn 16. And so in order to determine the capacity, a solicitor will normally speak to them on their own. And if they're not sure, they might ask to speak to a doctor, maybe a GP or another registered medical practitioner who's involved with your child, just to make sure that they do have the capacity to put the power of attorney in place. So a power of attorney is a solution for some people with additional needs, but not all. Now, since the 2000 Act that we discussed, there are two types of attorney that you can appoint using the power of attorney. So the first one is called a continuing attorney, and that basically just means a financial attorney. So the powers that you might give a continuing attorney would be things like operating a bank account, or maybe managing direct payments, employing carers, there might be applying for grants or collecting benefits, or maybe signing a lease or arranging a housing agreement. So it's all the sort of financial powers that you're looking at with the continuing attorney. The other type of attorney is called a welfare attorney, and you give your welfare attorney powers such as being able to maybe arrange a care package, or to decide where you should live, or maybe change where you're living if it's not working out. Your welfare attorney would have access to confidential information such as your health records, and your welfare attorney could consent or withhold consent to medical or dental treatment. And your welfare attorney really is also there to sort of fight your corner if there's maybe organisations that aren't carrying out their obligations. So that's what the welfare powers are. And clients are often quite surprised to learn that if you don't grant a welfare power of attorney and you lose capacity, the right to decide where you live and what care you receive ultimately ultimately is with the local authority. So a lot of people would think it's their next of kin, mum or dad, husband or wife, whoever. But if there's no power of attorney or no guardian, it is the local authority who has the final say on that. So if you think your child might be able to put a power of attorney in place, when should they do it? Well, we would say it can't be before they turn 16, but as soon as possible thereafter, you want to look at getting a power of attorney in place, especially if their ability to understand the power of attorney is maybe going to deteriorate over time. You want to get it in as soon as possible. So we've prepared lots of powers of attorney for 16-year-olds, 17-year-olds, 18-year-olds who have had various learning difficulties, but who are able to understand and grant a power of attorney. And that results in huge peace of mind for the parents and the family, because they know that they are able to make decisions for that person if need be. But it does have to be the youngster's informed decision. So ignore anyone who says that powers of attorney are just for the elderly. And powers of attorney can be tailor-made as well. So it's not an all or nothing. We start off with a very comprehensive style, and it's got all sorts of powers to cover every eventuality. But it might be that, it might be that you're not comfortable with a certain power, and so that can be removed from the document, and it can be tailor-made depending on what the person feels comfortable with. And and you can have different people responsible for different things. So, you know, you might say mum and dad and sister, for example, are going to be the welfare attorneys, but maybe only mum and dad are going to be the financial attorneys, for example. So it can be different people working on the different sides, whether it's the financial or the welfare. And you can also have substitute attorneys, which means that if who you've appointed is not able to act for some reason, the substitute attorney then steps in and is able to start to act as attorney. So the powers of attorney, they have a certificate at the back, which has to be signed by either a solicitor or a doctor who is basically saying that the person has the capacity to put the power of attorney in place. And that's one of the safeguards that was introduced by the 2000 Act. And the certificate basically confirms that the document has been understood by the person putting it in place, and also that they're not under, you know, pressure or duress to sign it. It is their decision to do so. And that's, as a solicitor, that's our job to make sure that that's the case. So who can be an attorney? Well, it's pretty much, it's up to the person putting it in place who they want to appoint. But the key thing is it has to be someone that they trust. There have unfortunately been cases where attorneys have, you know, abused their power as an attorney. I think it's very rare, but it does happen. So it must be someone that you trust and that you know will do the right thing. I'm often asked, well, how many attorneys should I appoint? And the answer is, you know, you need one who's at least able and willing to do the job, but it is better to have more than one, just in case something happens to one of the attorneys. And my feeling is, if there is 2 or 3 people who are willing and able, then, you know, much the better, if you trust them all. But if you have any reservations, you know, then you shouldn't appoint that person as an attorney. Some people choose relatives and friends as welfare attorneys, but they're maybe not as keen or as comfortable to have them on the financial side. So you can have professionals who deal with the finances. Powers of attorney, before they can be used, they've got to be registered with the Office of the Public Guardian. And that's another one of the safeguards that was brought in by the 2000 Act. So if you are appointed as an attorney, what should you do? Well, you should act reasonably, you should act in good faith, and you should follow those 5 general principles that I told you about. There is a code of practice for attorneys, which you can see on the Office of the Public Guardian's website. And I'd say the Office of the Public Guardian are really, really helpful. So, you know, if you do have any questions, it's good to ask them. If there are ever any concerns raised about an attorney, then the local authority and the Mental Welfare Commission are able to investigate, and they would investigate on the welfare side, whereas the Office of the Public Guardian would investigate on the financial side if there was any concerns. But ultimately it could end up in court, and a court does have the power to revoke a power of attorney, or maybe impose supervision of the attorneys by the Office of the Public Guardian. So that's a summary of powers of attorney. It's putting one in place is a relatively straightforward, quick and easy process. And I think it really does give families, you know, peace of mind to know that if they do have to make any decisions on behalf of someone who's not got capacity, then they are able to do so without any barriers. And, you know, we would advise that absolutely everybody has a power of attorney, you know, just in case it is needed. So what if there's no power of attorney in place and a person loses capacity? Or maybe you have a child who's going to turn 16, but you don't think they're going to have the capacity to put a power of attorney in place. In that scenario, there might really be no option other than to ask the court to give you authority to act on your child's behalf. For example, through an intervention order or by becoming a guardian. So if we look now at intervention orders, I'm just going to speak about them briefly because they aren't as common. So an intervention order covers a situation where decisions have to be made for someone who doesn't have capacity, but it's just a one-off decision or a one-off event. So for example, it might be that you need to sign a tenancy agreement on behalf of your child when they become an adult, or that you have to sell a property, for example. But if there's ongoing management of the tenancy agreement, or if you wanted to take the sale proceeds from the sale of the house and then invest them, then the intervention order isn't going to cover it. And in that case, you need something that's going to allow you ongoing authority to act on behalf of your child. So intervention orders are only really appropriate if there's a clear beginning and end to what's required. If the authority is going to be needed on an ongoing basis and the person is not able to put a power of attorney in place, then we look to the sort of last resort, which is the guardianship order. So a guardianship order is when you seek authority from the local sheriff court to be a guardian to an adult who doesn't have capacity. So that's an ongoing appointment, and it's suitable where you're going to maybe need to manage your child's finances or make decisions about their welfare on an ongoing basis. It's a bit like being an attorney under a power of attorney, but instead you are a guardian appointed by the court. Now, it used to be quite common that guardians would be appointed for an indefinite period, so it might be for the rest of, a person's life. But it's not very common now, and it tends to be that the younger somebody is, the less likely you would get an indefinite order. So usually your guardianship order might only last for 3 to 5 years, and at that point you would need to renew the order again. So what's involved with the guardianship order? Anyone who has an interest in the individual's affairs can make an application to be appointed as a guardian. So as far as your children are concerned, then you could make the application to be guardian to them. And you could either be a financial guardian, or you could be a welfare guardian, or quite often you would be both. You can sometimes have competing sort of applications from different family members. Or you might have someone object to your application, and that's, things can get a little bit more messy when that happens, but it might be that, someone from our sort of litigation team, for example, would step in at that point. Often when that happens, an independent person known as a safeguarder would look into it and do a report on who the more suitable guardian is. And if there's no one willing to act as guardian, in that case, the local authority is obliged to make an application. So the application will set out what powers are needed and why they're needed. And you also, along with your application, you need to have 2 medical reports prepared. And those confirm that the child, or who's now about to become an adult, doesn't have capacity. So typically you might get one from a GP and one from a consultant psychiatrist. And if you're seeking welfare powers, you also will need to get a report done by a mental health officer. So you can see with guardianships already, there's quite a lot more needs to be done than compared with a power of attorney. So the mental health officer would do a report, and they work at the local authority. And in theory, within 21 days of telling the local authority, a mental health officer should be appointed and a report done. But most local authorities are very busy. And so I'd say at the moment in Edinburgh, if you're looking to get a mental health report done, it could take at least 6 months. I'm not sure, you know, what the position is like on the West Coast, but I found it differs depending on where the adult with incapacity lives and how busy their local authority is. I've done guardianships in Perth and in Fife, and it only took a couple of weeks to get a mental health officer's report, whereas in Edinburgh, as I say, it can take a number of months. So the timescales really depend on where you live. So I would say if you are thinking about going for a guardianship, then you should start early, because by the time you do get all the reports in place and it makes its way through the report, in Edinburgh, a guardianship can take about a year to get it in place. So yeah, as I say, you can see it is a lot more time consuming, and it is a lot more complicated than just putting a power of attorney in place. So once you have your reports and your application, it's all submitted to the court, and the court will then ask for a copy of it to be sent to everyone involved with the adult with incapacity. So it might be family members, the nearest relative, the primary carer. They'll also let the local authority know, the Mental Welfare Commission, and the Office of the Public Guardian, and anyone else that the sheriff, that's the judge, thinks it is appropriate for them to have a copy. And at that point, the Office of the Public Guardian will usually get in touch with the proposed guardian to discuss things with them. And that's just to make sure that you're clear as to what you're expected once the order is granted. So what's expected of you. And I think the reason for this is that, you know, there's been people in the past have got themselves appointed as guardians, maybe without fully considering what's involved and not realizing how much work it is. And that can lead to the breakdown of the guardianship, or to it not getting sort of properly set up and started. So being a guardian, it is a lot of work, and it's not something that people should take on lightly. So everything's in at the court. What happens next is a hearing will be fixed, and this is in private, so it means that there's not members of the public at the hearing. It's behind closed doors. And generally speaking, if you've got a solicitor representing you, they'll go to the hearing, and you don't have to be there, but you can be there if you want to. And if there's no objections, and you know the sheriff is happy with the application and the reports, then you know the hearing can be relatively short, and all being well, the guardianship can be granted at that hearing. So in terms of timescales and costs, as I say, it can take around a year in Edinburgh to get a guardianship from start to finish. And so I think it is important that you start planning early if you do think you might have to get a guardianship. The cost of guardianships, if you're doing it on a private basis, then it could cost, you know, several thousands. But provided there's a welfare element, so that means that you are seeking some form of welfare powers in your application, then you are entitled to non-means tested legal aid. So that means regardless of how much money the adult with incapacity has or you have, you will get legal aid to cover the cost of the application. So, you know, it's important though to if you are looking to get legal aid, to go to a firm that does offer legal aid. If for some reason you're only looking to get financial powers and not welfare powers, which is quite unlikely, but it can for various reasons happen, then in that case you're not entitled to the non-means tested legal aid, and so legal aid would have to be assessed on, you know, depending on how much money the adult has. So if you do think you need a guardianship order, or you know, when should you get the ball rolling? Well, I would say at least maybe when your child's 15 or so, you could make a start and find out from the solicitor in your local area, you know, how long it takes where you live to get a guardianship through the courts. The thing is, if you leave it until your child turns 16 to start, and if it, say, you know, if it was like Edinburgh and it's going to take a year, between your child being 16 and 17, it means you don't have any authority to act for them. And you've lost the authority as a parent because they're now an adult. And so in that intervening period, you're kind of stuck without being able to make decisions. So I would say it is important to think about guardianship and plan ahead. So if you're appointed as a guardian, what are your duties and your responsibilities? Well, the first thing is you've got to prepare an inventory and a management plan. And these are pro forma documents which are produced by the Office of the Public Guardian. The inventory states what assets and income that the adult with incapacity has, and the management plan sets out what you, as the financial guardian, plan to do with those assets and that income. Now, both of these documents you must lodge with the Office of the Public Guardian within 3 months of your appointment as guardian. The other thing is you have to keep records and you have to submit annual accounts to the Office of the Public Guardian. So you'll have an account of any income and any outgoings, which has to be submitted each year. And you also want to keep receipts as well, and those should be submitted with your accounts. So again, it is quite an onerous task, especially on the financial side, and there is quite a bit of paperwork involved. So it's important that any potential financial guardian, realizes that they are going to have to do these tasks. And finally, again, you remember the 5 principles we talked about. It's really important, if you are acting as a guardian, that you keep those 5 principles in mind when you are making decisions for the person with incapacity. And if you're ever stuck on if you're doing the right thing, go through the principles and work out whether you're meeting them. And again, the Office of the Public Guardian are really helpful if you do have any questions and you're not too sure what to do. So to round up, just remember, it's never a case of choosing between power of attorney and guardianship. The individual circumstances of each case will determine which one is appropriate. The power of attorney can only be granted if the individual has sufficient capacity to understand. And I appreciate that some people will have lost that ability, or they might never have had the luxury. So where you don't have the ability to understand a power of attorney, then you have to look at maybe an intervention order or a guardianship order. So for those who do have capacity, when they turn 16, putting a power of attorney in place, it can save having to go through the guardianship process. It can save a lot of hassle, a lot of money, and it can put everyone's mind at ease just to have it there in case it's needed. And if you are going for the guardianship route, I'd say it's just important to take advice and start the ball rolling sort of sooner rather than later. So I hope I've given you a useful overview of how the adults with incapacity legislation works, and whether a power of attorney or a guardianship might be suitable for you or your child. But as I say, every case is different. But the thing that's always remains the same, always a constant, are those 5 principles that you should keep in mind. So that should be me. I'm just going to stop our screen share and I'll just stop the recording.